manager of Condor, Phil Fisher's alternate legal service business. I'm joined today by my colleague James Corlett, a partner in Phil Fisher's commercial practice, and who is back for an encore performance after headlining our last webinar on Brexit and supply chains. Today, James and I will be considering the impact of Brexit on commercial contracts and what your business could and should be doing to ensure that it's ready to trade with minimal disruption when the transition period ends on 31st December. Now for some housekeeping. If you have any questions, please use the question box on the right side of your screen. We will endeavour to answer questions at the end of the webinar. If we're unable to get through the questions, we will follow up with you afterwards. If you have joined the series midway through, then and are needing a catch-up, the good news is that you can. All webinars can be accessed through the Phil Fisher website and our YouTube channel. Now, let's get started. For those of you who tuned into episode 1, Brexit and Overview, today's webinar will have a similar structure. We start with where are we now? What comes next? What does it mean for me? And by that I mean for your commercial contracts. What can I do? Or how to Brexit-proof your commercial contracts? And then we will attend to any questions. I'll now pass over to James for our first question. Where are we now?
Thanks, James. Good morning, everyone. Well, where are we? Good question indeed. For those eagle-eyed amongst you, you will recall me presenting last week's seminar. And unfortunately, little has changed on this front in the last week or so. So sorry for going over slightly old ground. You'll be able to see where we are and where we should be from the slide on your screens. The UK and the EU initially gave negotiators until the 15th of October to reach an agreement on the future relationship. And we're obviously almost a month past that, still no deal in sight. This has obviously pushed the boundaries for everything else in the final 2 sections of that slide, slightly towards the wall. Now, obviously, if both sides are able to agree to a deal, then it potentially needs to go through the necessary decision-making processes on both sides, and that's obviously dependent on the content. There's a limited time for the deal now to be ratified, or an extensive deal to be ratified in Europe, certainly. But obviously, like I say, it does depend on the content of the deal, and this doesn't rule out a deal being struck post the 1st of January. Against this backdrop, the UK is obviously trying to finalise the remaining continuity trade agreements, which the EU currently has with third-party countries. Notable deals yet to be concluded include Canada and Mexico as well. Negotiations there are still ongoing. As has been mentioned previously in the series, whilst there may be a deal, and sources are pointing to the fact that whilst we near the 11th hour, there may well be a deal struck. It's likely to be a skinny or thin wedge deal, so it's a very slim step away from no deal. It's worth pointing out the UK has been here before, but this really is the final countdown to the end of the transition period at the end of December. So in terms of what comes next, when the transition period does end on the 31st of December 2020, the UK will leave the EU single market and customs union. It'll then begin a new economic relationship with the EU, either with that trade deal or on no deal. For business planning purposes, the limitations and scope of any free trade agreement are known. The published UK and EU draft text set clear boundaries for the scope of what can and crucially can't be achieved through those negotiations. No deal would obviously mean reverting to WTO terms, and the implications of this outcome are probably mostly known. Regardless of an actual deal being reached in the next few weeks, it's safe to assume that there's going to be significant friction on trade between the EU and the UK, and also this will likely impact wider relationships too, particularly where the UK can't or hasn't been able to roll over those existing trade deals that I talked about previously. This is all obviously set across the backdrop of the COVID-19 pandemic, albeit that there's been a bit of a bounce this week on the back of some positive news in relation to a vaccine the UK is obviously entering into slightly unstable waters, and we'll talk through the remainder of this seminar as to what you can do and the issues to be addressed between now and the end of the transition period. I'll throw back over to James in terms of what this means for you.
Indeed. And James, when I was reflecting on this question, I was reminded of the story of the three little pigs. We'll all be familiar with that story. Three pigs were sent out into the wide world by their mother and were aware of a threat that they needed to deal with, a wolf. All three knew the solution to that particular threat was to build a house to keep them safe, but each took a different approach in their response to that particular threat. And actually, there are some commonalities between the story of the three pigs and Brexit, and some lessons that can be learned. In that story and with Brexit, there is a change of circumstance. Three pigs left home, and the UK is leaving the EU. Three pigs, they had a potential threat to deal with. Well, business here is having to deal with the threat posed by Brexit and the risks and issues that it presents to their business, both internal and external. The pigs, well, they need to take action for their future security. Businesses are needing to take action to ensure that they are well placed to meet the challenges that Brexit presents to them. The pigs, well, they had to evaluate a range of options, and they responded differently to the perceived risk of the wolf. They had to choose what building materials to use. Well, for business is in the same situation. There are a number of options available as to how they respond to the Brexit threat. And finally, there were very different consequences resulting from the action or inaction that they took. The risk with pigs was being eaten. Well, with Brexit, the risk is for business, it's about being able to continue to trade and trying to minimise the disruption that Brexit perhaps brings with it. And for our clients and for business, it's about trying to turn the threat of Brexit into an opportunity for business. So, what does Brexit mean for me and for my commercial contracts? Well, over the past 7 webinars, we've examined the legal impact of Brexit, and we have looked at how businesses could and should be preparing. We've looked at the issues of how EU law will be incorporated into UK law with a focus on competition law, trademarks, intellectual property. We've also looked at the data protection issues that will arise from Brexit. And last week, James addressed how Brexit could impact businesses' supply chains. This week, as we discussed, we are looking at how contracts are impacted by Brexit. And these are contracts that you have with your customers and with suppliers. And what's clear is that there is a material difference between, the risk that the wolf presented to the three little pigs and Brexit. Brexit is not a single risk. The impact that it will have on businesses is varied. So for that reason, the houses that businesses are building in response to Brexit are varied. Now, commercial contracts may appear neutral as to whether or not the UK is a member of the EU, but as we will see, Brexit is likely to have a significant impact on your commercial dealings. And as the diagram illustrates, our view is that Brexit needs to be considered from 2 different perspectives, the perspective of the customer and the supplier. Now, James, if you were to be advising a supplier on how Brexit might impact its commercial contracts, what are the key risks and issues that you would be discussing with your client?
Thanks, James. So as James outlined, there are different things to be done, and suppliers will obviously most likely face the brunt of remedial actions that will be required in the light of no deal Brexit. Depending on the nature of the particular agreement, obviously the advice would change. Some customers may be able to run the risk of doing nothing, but that luxury is less likely to be afforded to suppliers depending on their industry or sector or particular nature of the contract. Brexit is likely to have a significant impact on that commercial bargain, if indeed there is any cross-border trade, either from directly affecting the supplier or indirectly through supply chains. It's worth pointing out at this point that the situation isn't novel. We've had 4 years to prepare for this. Many businesses are in fact ready. And pleasingly, from the polls that we ran on last week's webinar, this seems to be backed up by our clients and contacts as well. I guess it's worth pointing out that there's no standard Brexit clause that is going to protect suppliers here necessarily. One would probably look at the individual impacts that Brexit may have on those supplier arrangements. And the effects are likely to cover those areas that we've already articulated throughout the series. So I guess primarily, a no-deal Brexit may possibly lead to increased costs, different regulatory requirements and potential non-tariff barriers such as delays, all of which will hit and affect suppliers whose trade flows across UK-EU borders. On a practical level, that's going to lead to inbound and outbound transport routes facing additional logistical pressure points, and that presents a high delivery risk. It follows from this that the impact of no deal will be determined by who in the supply chain actually has the responsibility in relation to goods movements and whether they are prepared. As we've highlighted when dealing with trading goods, it's most likely to impact the suppliers, but key in assessing this will be whether appropriate Incoterms, which decide who would be the importer or exporter, are included, where the goods are actually going to be delivered, and who has responsibility to clear the goods for export, and what are the consequences of any delay related to that. Now, as I said, we've had 4 years to prepare for this. It may well have already been dealt with. But even if you think that it has, it's well worth assessing the potential financial risks and assessing those again in light of recent developments in the US and also in respect of the overlaying COVID situation. It's unlikely that if an agreement becomes a bad bargain, that the courts are going to provide any relief. That will obviously turn on the wording of the contract and the specific impact that Brexit will have. But in general terms, as we've seen from some previous decisions, English courts are reluctant to step in and are fairly strict in holding parties to a contract, even if it becomes financially burdensome or uncommercial. It's worth remembering that your supplier business may well be impacted due to increased costs, even if you're not the direct importer or exporter. And suppliers have got to consider the performance and cost of that performance by their subcontractors and sub-suppliers, and looking at how robust the respective subcontracts are and any costs that can be passed on either to subcontractors or ultimate customers. It's worth saying that customs processes are likely to fundamentally change depending on the types of products that are being moved across the border. The suppliers are going to need to consider the practical impact of that. The impact of staged customs arrangements and deferred declaration processes need to be considered as well. Pricing is going to be key here. There's probably going to be increased costs related to additional border checks, and currency volatility will play a part as well. Customer remedies, there's likely to be an increased chance of termination due to specified breaches or failure of performance. Perhaps slightly less impactful, but still material, could be the effect of liquidated damages or penalties for performance failure. One key thing for suppliers is time of the essence. This is obviously a high risk factor for suppliers generally, but particularly where the agreement was entered into in contemplation of Brexit and its consequences. And there is, in such circumstances, no bandwidth to point to frustration or force majeure as a potential get out here. It's worth highlighting, as James will look to articulate shortly, that some customers may also be proactively horizon scanning for potential issues in their supply chain. The lack of an impact assessment or remedial planning may lead to them reprioritizing its supply chain, leave you vulnerable as a supplier at renewal periods or when approaching expiry. There's also potential territorial limitations in your existing contractual framework. So, for example, in the case of license or franchise agreements, that could have the inadvertent effect of reducing or removing your ability to supply products. And it's also worthwhile bearing in mind whether or not either party or their personnel lose the benefit of recognition of EU-wide licensing or approval arrangements as well. References to EU laws might become redundant or take on additional requirements in the case of regulatory divergence between the UK and the EU, and suppliers have got to be alive to those issues. Related to that, it's obviously common for contracts with UK-based public bodies to allocate change in law risk to suppliers, and it follows that this is a likely position more generally, so it's certainly one to watch for. Data is another important point to mention. So when the transition ends, the UK will be a third country. Are there additional measures that have been put in place to facilitate the transfer of personal data to affiliates and third-party processors? It's also worthwhile pointing out that there's going to be additional regulatory obligations here, which means separate breach reporting, separate regulatory oversight, exposure to UK and EU fines for non-compliance. And there may be data localization requirements to consider as well. As UK and EU laws diverge, commercial contracts will have to address those issues where there was previously alignment between the UK and the EU. One example of this that suppliers have to be aware of is in respect of competition law. There will be many situations where a UK supplier imposing cross-border sales restrictions on distributor licensees within the EU will need to continue to take account UK law, whilst it may no longer apply in the UK. Depending on the terms of the exit, Brexit could in some cases render a contract illegal to perform due to events beyond the party's control as a result of the decoupling of regulatory alignment. Well worth bearing in mind and putting strategies in place if that hasn't been done so already. I'll pass over to James now for a perspective from the customer side.
Thanks, James. Yeah, so I know a number of customers might take the approach of doing nothing on the basis that actually, as James has articulated, they perceive the primary risks of Brexit as being associated with suppliers responsible for delivery of goods and services. And those businesses, customers, may rationalise their approach on a number of different particular points. They may well say, as James has indicated, that EU law is being transposed into UK law when the transition period ends, and that they would expect their suppliers and courts to take a purposive and commercial approach to the interpretation of contractual references to territory and to EU law. Those businesses may also take a view that, well, they're the beneficiary of the contract, and actually the obligations the customer's obligations are essentially limited to paying for goods and services that are delivered in accordance with the contract. And actually, I've got rights and remedies in the event that my supplier fails to deliver those goods exactly as required. Those customers may also have heard that the courts are unlikely to treat Brexit as a frustrating event. James mentioned this earlier, but there was the Supreme Court decision in the Canary Wharf and European Medicines Agency case last year, which has given, I guess, further emphasis to the fact that businesses are expected to make adequate preparations for Brexit and are unlikely to be given relief from their contractual obligations. That said, as James noted, Brexit has been something which businesses have had to be preparing for 4 years. And so whilst there is no one standard Brexit clause, some suppliers, where doing business on standard terms, may well have incorporated Brexit-style provisions into their standard terms and conditions, which give the suppliers rights to suspend provision of services, to reprice, or to exit the contract should Brexit impede their ability to deliver. So the do-nothing approach is an option for customers. It's not one that I would be encouraging. I'd be encouraging my client to review its contracts. Now, what we have to recognize is that that's not a simple exercise. Many customers have hundreds or thousands of contracts, and so that is, a large logistical exercise. So what is needed here is to be proactive, to think about what is, a priority for the business and to deal with those. It's better to be proactive, to understand what are the risks and issues, and have the option to put in place measures to mitigate and avoid those risks and issues. The do-nothing approach is really relying on the terms of the contract and your rights and remedies should something go wrong. And as we know, well, many of you will know, that where there is a dispute, that is an additional business cost, both in terms of time and money. And disputes are rarely certain, and they take time to resolve. And whilst that dispute is ongoing, there is, potential interruption to the supply of the goods and services that you require. And whether those are goods and services that you are receiving simply for the purpose of operating your business, they may also be goods and services that you're receiving and essentially repackaging it in terms of goods and services that you sell to your own customers. And so that interruption itself creates further business risk. So this brings us to where to start and what to do. Unfortunately, there is no prescribed solution for Brexit. This isn't a repeat of the GDPR, where all businesses that were processing personal data were required to insert Article 28 compliant data processing provisions into their contracts. GDPR repapering was simple in theory, but complex and expensive in practice. And a key issue for that is that a contract represents an agreement between the parties. It's rare that one party has a unilateral right to amend a contract. Written contracts require that amendments are in writing, or typically require amendments are in writing and signed by the parties' authorised representatives. And what this means is that counterparties need a reason to accept the change that is being proposed to the contract. If a change is required by law, then they may be less resistant to that change. But it does not mean that the counterparty will accept the variation. And this was something that many businesses learned as they set about remediating hundreds and thousands of contracts as a consequence of GDPR. So, when James and I were discussing this earlier, we said we would caution clients, both suppliers and customers, from undertaking mass repapering exercises, except where the changes are essential for legal compliance purposes, or where the cost of not attempting to make the change would put the future of the business at risk. So, what is the solution? Or what is it that businesses could be doing to Brexit-proof their contracts? As we know from speaking with clients and the polling that was done in our previous webinars, most businesses have commenced their planning for Brexit, and many businesses now consider themselves ready for a no-deal Brexit. In which case, the steps that we're proposing that businesses take and what we suggest that businesses should be doing will hopefully accord with the plans and the preparations that businesses have already implemented. We're articulating or recommending a three-step approach. The first recommendation is to focus on new contracts. This is a quick win, future-proofing your own contract templates. This is an action which is entirely within our client's own control. As outlined earlier, the approach that you take and the provisions that you amend will depend on whether you're a supplier or a customer. Going through your templates, you're likely to be looking at, are there references to the EU which need to be revisited and perhaps amended? Are references to the EU to include or exclude the UK? Many contracts include references to EU law. Both James and I have mentioned data protection, and it's common there for contracts to reference the European General Data Protection Regulation. But as a consequence of the Withdrawal Act, EU law will be transposed into UK law, and there will be replacement UK legislation. It's sensible to amend contracts templates now to reference those those UK laws, because as James indicated, post-Brexit, there is likely to be divergence. And what we want to avoid is having dual obligations. James also mentioned that Incoterms, we see customers and suppliers becoming more familiar with Incoterms in the post-Brexit world as a result of the border between the UK and the EU. Incoterms are a set of 11 rules issued by the ICC, which define the responsibilities of buyers and sellers for the sale of goods in international transactions. We see Incoterms being incorporated into more contracts, and buyers and sellers will need to decide which is the appropriate set of terms to be included, and that will have very specific consequences for responsibility, for insurance, customs clearance, and completion of the relevant forms. We also expect some businesses, particularly suppliers, to be looking at whether or not to include additional provisions relating to foreign exchange and cost of living adjustments. So having set about remediating contract templates, and in terms of new contract negotiations, so that would be updating playbooks and trading positions to inform negotiations with counterparties, the next task would be then to look at existing contracts. And as we've been saying throughout today's webinar, this isn't a case of putting all contracts through a review. It is about doing a prioritized review, looking at what contracts are critical to the operation of the business, examining those to understand the risks and work out what changes or workarounds need to be implemented. Now, if businesses have completed that exercise, then well and good, but there will be a number of businesses that are still haven't done that, and that could be quite a daunting task. And James and I will come on to how to do this and some of the tools that can be used this particular slide, referencing some of the data extraction and data analytics platforms that are available and that we do use to assist clients to essentially assess large volumes of documents and extract and analyze the positions and data points within those that are relevant to the business and the risks that we're seeking to mitigate. Having dealt with the contracts that are critical to the business, then as James dealt with last week, there is a need to look at the other vendor agreements that you have that are delivering important goods and services into the business, and what your supply chain is doing or could be doing to ready itself for Brexit. So, what can we do and how do we prioritise the review? James, I can see here that we've got a question, is it on my standard terms? What is it that we're trying to get at here?
Thanks, James. So it's likely, we would hope to assume that when you're trading on your own standard terms that you've updated that template over the course of the previous 4 years to reflect some of the impacts that Brexit might have on your business. If not, then we would suggest reviewing those templates, and where you have the ability to be able to include those into the commercial relationship, you do so. As part of this process, I guess, importantly, you need to be reviewing and confirming with your suppliers, customers, and other commercial partners as to whether or not they're ready, whether or not contractual liability, therefore, is back to back by your own terms. Is there a mechanism in your terms to unilaterally change the existing terms that are in place that may have been overlooked to date? If you do have such a tool in your belt, then it's well worth having a look and seeing whether or not that's something that you might want to be able to exercise. Like James mentioned, that we've sort of outlined a few tools here. So, James, I guess back over to you for whether or not that particular contract is business critical or long term.
Yeah, so Brexit is a particular challenge, and businesses have a large volume of contracts, so not all contracts are equal. Now, the assessment of whether a contract is business critical or I guess a contract with a very important customer, if it satisfies either of those criteria, then it merits prioritization over contracts that are perhaps less critical. Businesses only have a certain amount of time and budget, and so that time and budget needs to be used wisely to focus on addressing those key risks. As said earlier, the ability to prioritize will depend on what contract management tools clients have in place in first instance. Actually, what has I think GDPR demonstrated to me is that the businesses simply have a real challenge in knowing what contracts they've entered into, who they're with, when they expire, and perhaps haven't yet got a tool in place which helps them to prioritize. In the old days, to assess whether something was business critical or with a VIP, you might have to print off hundreds of contracts and then have your team do a page turn and fill out some sort of report. As we indicated earlier, thankfully today, there are tools that can expedite that process. So you could, for example, put your contracts through a data review platform like Kira, like HiQ, like Liberty, and ask questions of those contracts, and then the platform will extract data to help you to make that informed decision whether or not it should progress through to a prioritized review. But James, the next segment on the wheel, will performance be impossible, difficult, or more expensive? We've touched on this before, but do you want to go into why this is again relevant?
Yeah, sure. So you'll see on the slide here, we've got two arrows. So obviously option one, which isn't listed, James mentioned earlier, which is doing nothing. The other options are potentially amending existing relationships or even looking for an exit. Now, the trouble with the fact that Brexit, albeit that we've not known its final form and perhaps still don't for the last 4 years, is it's been something that's been foreseeable or something that perhaps should have been dealt with already. So it's going to be very difficult for suppliers to be able to exit contracts on the basis of frustration or force majeure or similar. Nevertheless, it's worthwhile considering as part of this prioritised review as to whether or not that contract is going to become impossible or just simply more difficult to do, and assess whether or not you have in place mechanisms to update pricing or reflect changes in the framework around the contract to allow you to either pass on additional liability back down the supply chain or additional costs to your end customer. And likewise, worthwhile considering here at this point that the currency fluctuation, which I mentioned earlier, all commentary at the moment points to the fact that there might be some volatility over the next few months. And it'd be interesting to see whether or not this has been allocated and the effect that this may have. And what we've seen is some clients modelling the impact of this on their supply chains and customer contracts. If it hasn't been done so yet, can it be? And that's the amend error there. And likewise, in connection with services that are being offered, is there anything that will materially impact delivery of those post the 1st of January? I guess in terms of the next step to consider is obviously a key one as to whether or not it is actually a cross-border transaction.
Yeah, thanks, James. And I think in terms of the topic that you were just addressing, will performance become impossible or difficult or more expensive? It is interesting. We haven't yet seen mass repaperings, but for businesses where perhaps the imposition of tariffs would impose expenses on the business that make trading very difficult, then we might well see businesses doing a sort of mass outreach to customers seeking to amend contracts with those sort of GDPR style cover letters. And if we don't hear from you in 30 days but you continue to have dealings with us, then that will be taken as an acceptance, and perhaps trying to rely on a course of dealings to amend the contract. But that itself is not a foolproof solution, because as we know from the Supreme Court decision in Rock Advertising, they've taken quite a strict view on how contracts can be amended where there is a no oral amendment provision. But dealing with this next segment, cross-border transaction, I think, again, this is a relatively straightforward question for businesses. If it's a contract with a UK-based supplier for a UK-based service, then that is perhaps a lower order of priority than one where you have dealings with a counterparty based in the EU, or the services that the counterparty is providing are to you and your affiliates based in the EU or in third countries. It's not a straightforward question. You can't simply determine that by looking at the counterparty's registered office address, but it's a question that should be asked and answered in order to assess how to prioritize your contract review. James, delivery. The next question, will delivery be affected in the EU?
Yeah, so I guess it's an extension of the one you were just talking about there. So where that is the case, where delivery will be affected in the EU or is currently, clearly the sensible option is to directly engage with stakeholders in the supply chain and define those customs and borders roles and responsibilities via Incoterms, perhaps to ensure a clear common understanding of the practicalities of the handover of risk and responsibility through the supply chain, obviously with the intention of avoiding those unexpected delays or costs. As James has already mentioned, it's really key there to document any of those agreements that are reached with third parties, in order that you can rely on those later on in case there is a dispute. Incorporating clear protocols around shipping delays, customer responsibilities. For example, you might want to look at potentially shifting responsibility for customs clearance under a DDP situation to potentially DAP, depending on where you sit. And you should also assess the availability and feasibility of risk mitigation strategies, such as whether or not you could reschedule transporting or arrange alternative transport arrangements, and see whether or not you could work with your suppliers and customers to create contingency plans to minimize that downstream supply chain disruption. We've also seen clients and businesses establishing control towers to oversee supply chain operations in the run-up, so that over the course of the next few weeks, with the hope that this would provide some sort of early warning tip-off type system, so that these issues can be foreseen and dealt with in practical terms. And then lastly, on the wheel, we've talked about when the contract actually expires, so I'll throw back over to James for that.
Yeah. Yeah, another obvious question that needs to be asked. If a contract is expiring before the end of the transition period, then obviously it should be excluded from the review process. But then businesses need to look at the contracts that are expiring post 31 December. If a contract is long-term, so going beyond, say, the 6 months, into the 2021, then those are contracts which, perhaps should be prioritised over contracts that are perhaps expiring in, Q1 or H1 of 2021. But the duration of the contract is something that needs to be taken into account when considering the review. So that brings us to the end of the, webinar in terms of how we suggest going about Brexit proofing contracts, what can be done, what sort of methodology can be implemented. I guess now it's over to the audience for any questions that you may have. And we'll just check the question box now to see whether any questions have been posed.
Yeah, we just got one here, James. Thank you for that. So basically, the question is whether or not there is time to do anything between now and the end of the year. And obviously, we've talked about priority, but actually what can be achieved over the next 35 working days, 34 working days, I think it is.
Okay, well, I think the answer is it's never too late to do something. And actually, if anything can be learned from the GDPR experience, businesses are still in the process of moving towards compliance and remediating contracts as a consequence of the implementation of GDPR. Indeed, Condor business has only just been instructed on a remediation of 250 IT contracts, with that project starting on Friday. So the fact is that there is an opportunity for a business now to set about trying to do some of the things that we have recommended. And the fact that that remediation project may continue beyond the 31st of December, well, it's neither here nor there. The important thing is that there is a risk, there is an opportunity, and there is time for the business to start to put in place some remedial measures. And that's where the use of technology and these e-discovery or data extraction platforms can be of great assistance, because there is the ability to digitize contracts, put those documents onto a platform, and then use the machine technology to interrogate those contracts and help the client to then prioritize what it does next. Well, it doesn't look like there are any further questions. In terms of the Brexit resources, if you are looking for some additional guidance on how Brexit might impact your business and what you could be doing, there are a number of Brexit resources available on our website for download. We also have, as mentioned earlier, the webinar series available both on the website and on our YouTube channel. That brings me to our last slide, which is to announce the final webinar in our series, which is next Thursday on state aid and public procurement, which will be hosted by Brexit lead Andy Hood. So thank you everyone for your time and attention. This is James signing off.